Daf Yomi is dedicated for Yeshua, for Hatzalah, for Geula, for all of Am Yisrael. Special prayers that all those who are captured be released speedily from captivity. Special protection for all those who are serving Am Yisrael by serving in the Israeli Defense Forces. We're going to start on the bottom of 13b, 7 lines from the bottom. The Gemara is analyzing a brisa that was said. Amar Mar, it said it in the brisa. The brisa was basically commenting on the Mishnah. It said in our Mishnah, Keshehizik chav hamazik. When it says when the damage is done, the damager, the mazik, is responsible. Now this line is seemingly superfluous. So what's it coming to include? Why is it repeated? So says the Gemara, it's coming to include that if somebody was a guardian, any one of the 4 major guardians, a guardian for free, a borrower, a renter, somebody was paid to guard, that he's going to be responsible. So the Gemara says, well, what's the scenario which we're referring to? If you want to say the scenario we're referring to is where the ox of the one who lent, somebody lent an ox to a borrower, and that ox borrowed, and that ox damaged the borrower's other ox. So if you want to say the iske sor demashel or sor de shoel, well, why would we think that the borrower wouldn't be responsible there? He could say to him, ilu izik ba'alma ba'asal shulmei at hashta de iske or sor de dach. So he said, if in general you would have to pay, if the borrower would always be responsible, well, now that the ox, even though it was the lender's ox, but if the borrower would have been responsible, if the lender's ox, which the borrower is watching, borrowed the borrower's other ox, of course the lender is not responsible. Of course the borrower is responsible. So therefore, Ella, maybe it's talking about a case to Iske Torah de Shoel, or Torah de Mashal. If you want to say, well, maybe it's talking about a case where the borrower's own personal ox gored the ox that the lender had lent to the borrower. Of course, why would we think he's not responsible? So he said, we say to him, let's say in general, the lender could say to the borrower, if my ox would have damaged somebody else's ox, if my ox would that when you were guarding him, you would have needed to pay his damage because you're obligated to watch him. But now that hold on, let me say it again. You could say to if my ox, which was damaged by another person, you wouldn't needed to pay me the full damages because I lent it to you, and a borrower is responsible for own sin, and borrower is responsible. So now that your ox damaged my ox, of course you have to pay me full damages. You're responsible to watch my ox. So therefore, third possibility. So therefore, Olam, what are we talking about? What's the scenario which we're talking about? Well, Olam, we're referring to the following case: the Iski Torah de Mashil Torah de Shoel, where the ox that the lender had lent to the borrower gored the ox of the borrower. That's what we're talking about. So the Reuben lent Shimon an ox, and Reuben's ox, and so Reuben's ox gores Shimon's other ox. And so here what we're talking about is Shekibo of Shmira Skufo. So we're talking about a case where the borrower, when he borrowed the ox, he accepted upon himself the responsibility that the ox would not get damaged, but he never accepted upon himself, look, Kibo of Shmiras Nisko, and he never accepted upon himself that he would protect the ox from doing damage to another person. And so therefore, the responsibility not to damage remains with the lender. And so therefore, since the lender's ox, which he lent to the borrower, did damage, the lender is going to be responsible to pay for half of the damages. So the Gemara says, if that's what you were saying that the scenario is, then what's the next clause? Let's say the ox got out in the middle of the night. Oshar Partua listim, or let's say robbers broke a fence. The Zika Pater, that since that he's going to be exempt. Why? Because it was an ones. It happened. It happened that it escaped. But it implies that habayom chayev. But during the day, the borrower would be responsible. So during the day, the borrower would be responsible. But why is he responsible during the day? He didn't accept upon himself to guard the animal. So why would we say he's responsible? So the Gemara says, no, this is how we have to read the Mishnah. This is how we read the Brisa. Let's say the borrower accepts upon himself to watch the ox, he's responsible. But but if it escaped at night, or if the robbers broke the fence, it's going to be exempt. And that's what it's saying. So Gemara says, okay, so that we've completed that explanation of the Brisa. Gemara goes back to an earlier statement where Rebbe Lazar said that if it was a courtyard that was shared by two partners together, then we're not going to say the responsibilities of Shein and Regel, that there's no damages of Shein and Regel. Shein is tooth and Regel is foot. So that's the position of Rabbi Elazar. So the Gemara says, is this really the case? Eini v'atani Rabbi Yosef chatzar shutvim v'apunduk chayev ben al Shein v'al Regel. That Rabbi Yosef taught, let's say you have a courtyard of partners, or you have, let's say a pundak is an inn. Then you're going to be reliable for them for tooth and foot. So we see that this is for Shein and Regel. This is indeed a refutation of Rabbi Elazar, because Rabbi Elazar says in a courtyard of partners, you're not liable for Shein and Regel. So to you, up to Rabbi Elazar, Amrocha Rabbi Elazar, V'tizbara. Rabbi Elazar says, do you really think Masnisi Milo Pligi? Do you really think that this Brisa has nobody who argues against it? But Tanya, I'll say you a Brisa. Arba Kol, I'll say you Rabbi Shimon ben Elazar Omer. Shimon ben Elazar taught four general principles b'nizakin, and one of the four principles, one, kol shu b'shus l'nizak v'lo mazik, anything that's the domain just of the nizak, just of the damaged party, and not the mazik, then we're going to say chayev b'kol. He's liable for everything because the damager has no permission to be there, so he's liable for everything. Anything that is the mazik v'lo nizak, anything that's the domain of the damager but not the damaged, pater mikol, he's exempt from all damages. Let's say they both share. It could go in chatzar shutfim v'apika, like a courtyard of partners or a valley where they both are allowed to have access to. We're going to say there, pater. We're going to say under those circumstances, pater ba'al shein v'al regel v'al negicha v'al negicha v'al neshicha v'al vitza v'al bita. So he says he's going to be exempt for foot and tooth, and on the goring, and on the pushing, and on the biting, and on the kicking, and on the crouching, or the crouching and the kicking, if it's a tam, it's misham chatzin nezik. If it's a never done it before, pays half damages. If it's a muad, if it's expected, it's done it before 3 times, then we're going to say it pays nezek shalem. So first of all, before we finish the brisa, this is a brisa that supports Rabbi Elazar, because here it says that if it's a shared courtyard and it's tooth and foot, you're going to be chayav, whereas the earlier brisa said it's pater. So we see that there Rabbi Elazar has his own brisa that he can rely upon. But now, what's the fourth case? Because we said there are 4 cases, and then we say in the fourth case we said. In the fourth case, we say chatzar shel lolazev lolazev. Let's say it doesn't belong to either one of them. Could go chatzar she'eno shel shneim, courtyard that doesn't belong to either one. Chayev bo shein v'regel. Then everybody's going to say you're liable for, according to this price, you're liable on tooth and foot. On the gichav, on the chichav, on the gichav, al arvitz, al bita, tam mishayim chatzi nezek, and mua mishayim nezek sham. So here, unlike the previous case where it said that if they both have access to it, the Brisa says they're pater on shein v'regel. Here it says you're liable and shein v'regel if neither one is allowed to have access to it. But katani miyas, so this price does support Rebbe Elazar, because it says chatzar shutim v'apika pater b'al shein v'al regel. So this price says explicitly that if it's a shared courtyard, you're going to be exempt for tooth and foot. So kasha adadi, so the 2 prices are contradicting each other. So the Gemara says, okay, how do we deal with one brisa that says you're liable on shein v'regel in a shared courtyard, and the other brisa says that you're exempt on shein v'regel in a short courtyard? So the Gemara says, Kitanya. So the Gemara says we're going to have to answer that the the brisa of Rabbi Shimon ben Elazar, which says that shein v'regel, you're exempt in a shared courtyard. That's b'chatzar miuchadus lozel lezeh ben leperes l'shvarim. So he says in that brisa, the one that we found that we're trying to say is supporting Rebbe Lazar, that's because it's a courtyard where they have complete access to, both for fruits and oxen. But the Rav Yosef, but the brisa the Rav Yosef cited, which says that you are liable for shein v'regel, we're talking about there, b'chatzar miuchadus leperos ve'eno miuchadus l'shvarim. There, it's a courtyard that you're supposed to be using to grow fruit or watch fruit, but it's not a courtyard for oxen. Now, with respect to the tooth, the ox has no right to eat there, so it's considered the courtyard of the one who was damaged, and therefore you're going to be liable. Indeed, dekanami, we can indeed infer this. The katani hacha dumya de punduk, because in the case of in one brayse it says in the brayse of Rav Yosef, where he says that you're liable because it's like an inn, and in an inn you don't have permission for the ox to go in. The Katani Asam in the brayse of Rabbi Shimon ben Elazar, it says a bika, dumya de bika, a valley where the oxen do have the right to go in. So we're talking about courtyards that there's different expectations of what you could use them. So Shema Mina. So the Gemara says Maska for Rabbi Zera. So Rabbi Zera challenges even to Miuchedes Laperos. Well, since this is a courtyard that everyone has access to, so if that's the case, why would you say he's liable? You require it to be another person's field, but based upon the verse. But this is his field because he's allowed to bring his fruits in there. So Abaye answers very easily. Well, since even though he's allowed to go in there to access the fruit, since he's not allowed to bring his oxen in there, with respect to his oxen, it's considered another person's field. Well, why don't we say from the fact that the brises are not arguing, that they're just talking about two different scenarios? Maybe we'll say Rebbe Lazar and Rabbi Yosef are also not arguing, that they're talking about two different scenarios. Yeah, indeed, we could say that. And if you want to say that they're arguing, but Kushya did the Rabbi Zera, but Peruka did Abaye Pligi. They're arguing about the question the Rabbi Zera asks, and the answer, and the answer that Abaye gives, whether or not we accept Abaye's answer. Okay, so now the Gemara says, let's analyze this price of Rabbi Shimon ben Elazar. Let's analyze this price. So the price says, Gufa, Arba Klos, Aya Rabbi Shimon ben Elazar, Omer ben Izakin. Rabbi Shimon ben Elazar taught that there were four general places, four general places as it relates to, or four general rules as it relates to damages. The first one is kol shu rishos lenizak v'lo mazik, anything which is the domain of the damaged party, but not the domain of the damager, chayav b'kol. So he's liable for all. So the Gemara says, ala kol katani. It doesn't say he's liable for everything. Elo chayav b'kol. He's liable b'kuay nezek. He has to pay complete damages, meaning to say, if you're in the domain of the damage, if Reuven's ox goes into Shimon's property and damages Shimon's ox, then we're going to say he has to pay full damages. So who is this like? This price, it must be like Rabbi Tarfoni. This price, it must be like Rabbi Tarfoni. It says, Mishuna Karen b'chatzar anizak nezek shoem mishan. That even if it's a short time, if it's an ox, it's never gored before, it's Mishuna. We're not expecting this. And it gores in the courtyard of the owner of the ox that was gored. Rabbi Tarfon says there he pays full damages. He has no right to be there. You should have properly guarded your ox from going to somebody else's property. But before we can say that, Ema Seifa, but the next clause of the price says, Lozeh v'lozeh, that if neither one has the right, this is the last clause of the price, it says if neither one has the right to be there. If neither one has the right to be there, he's liable for tooth and foot. So there, my lo is that, below is that, and then it says at the conclusion of the brisa, it says that if neither one has the right to be there, then it says, hold on one second. then it says under those circumstances that the Tom pays half damages if neither one has the right to be there. But let's go back. It says here, he's liable for tooth and foot. My lo is that. If you want to say it doesn't at all belong to either one, it belongs to somebody else. If you want to say that it doesn't, if you want to say that under these circumstances that it doesn't belong to the Nizak or the Mazik, but it just belongs to somebody else who the Nizak put his fruits there without permission, and then the ox or the Mazik came in and ate them. You can't say that, because in order to be liable for tooth and foot, it needs to be that you're in the field of the damaged party. But that's not the principle here, because it's somebody else completely owns the field. It doesn't belong to both of them, it belongs to one of them. Now, which one does it belong to? It obviously must be belonging to the Nizak's property, because if it's the Mazik, he wouldn't be responsible. But Katani Seifa, but yet the concluding clause of that brisa says that Tam Misham Chatzi Nezek and Mula Misham Nezek, showing that if it's Mishuna, if it's a Tam here, he only pays half damages, even though it's in the domain of the Nizak. So us and Rabbanan, we have to say that this concluding clause follows the position of the Rabbanan, who say Mishuna Karen B'Chatzar Nizak Chatzi Nezek Misham, that even though it's goring in the domain of the Nizak, he's paying only half damages. So the Gemara says, would you really say from here, Reisha, Rabbi Tarfon, V'Sefer Rabbanan? Do you really want to conclude from here that the first cause is Rabbi Tarfon and the latter cause is the Rabbanan? The Gemara says, yep, that's what we have no choice. We have to say that. In the Amar Shmuel, Rabbi Yehuda, Shinina, Shok Mas Nisan, Shmuel calls the student Rabbi Yehuda, sharp one, abandoned your interpretation of the Brisa. Basra, you have to come after me and say Reisha Rabbanan, V'Seifa, Reisha Rabbi Tarfon, V'Seifa Rabbanan. You have to say the first cause is the Rabbanan and the last cause is the rabbis. Gemara says, Ravina Mishmei, the Rava Amar Kua Rabbi Tarfoni. Ravina says in the name of the Rabbanan that the whole brisa is Rabbi Tarfon. Again, what did Rabbi Tarfon say? That if it's in the domain of the Nizak and the Mazik's act does damage, he pays full damages, even though it was a tam. So we have to say that the Seifa is also the Rabbi Tarfon. So what does it mean when it says my lo is ev, lo is that? It's neither one's courtyard. It says lo is ev, lo is peiros, and neither one has the right to bring their fruits in there. Ela dechad was there. Ela dechad. One of them has the rights for fruits. But both of them have the right to bring their oxen in. With respect to the tooth, there we're going to say it's the domain of the courtyard of the Nizak. Karen, with respect to the goring, there we're going to say it's the public domain because they both have the right to be there. Mara says, well, if that's the case, if that's the case, why do we say? So if that's the case, why are we saying that the price that there's 4 principles? There's only 3 principles, meaning to say the first 3 principles, because we're not really dealing all those laws that were set in the 4th principle. They were already set in the first 3, because with respect to Shane, we're going to consider it like it's the domain of the Nizak. So if that's the case, there's why are we saying that there are 4 cases? There's really only 3. So the Gemara says, Amar Rav Nachman bar Yitzchak, Shlosha Klos Bava Kamma. There's 3 general rules, and there's 4 applications of these rules. We're talking about 4 specific places. There's 3 types of domains, and we're talking about the 4 applications of them, and that's all we're referring to. So there's 3 laws. What are the 3 laws? Rashi summarizes it for us, so we don't get confused. Thanks to Rashi. Rashi summarized it. We're so appreciative. What does Rashi say on the top of 14b? First of all, if you're in the domain of the one who's damaged, you have to pay full damage. If you're in the domain of the one who does the damage, you're pater mikol. Let's say it's a courtyard of partners, then chayev bit chatzi nezek karen upater al shem v'regla. If they share it, and then for goring you pay half damages, and for tooth and foot you're exempt. But But there are 4 places where they don't have the same law, because there's also a courtyard of partners where you're going to be liable for tooth. So what's that? For example, in a case where their fruits were designated for one of them and both of them are for ox. Okay, so now we go to the next Mishnah, and Mishnah and Bava Kamma are all said elliptically, cryptically. So the language here is it's cryptic. It's not so obvious. So we say shum kasef. We don't know what this means. Rashi says kula masnit mefarsh v'gemara. The whole Mishnah is going to be explained in the Gemara. We just have to read it. Shava kasef, the equivalent of money. Bifnei bezin, in front of a court. Valpi edim, with witnesses. Bnei chorin, bnei bris, v'anashim. So these are people who are free Jewish women. The klal hanezek, v'anizak, v'amazik b'tashlumin. They're included in damages. And then the last thing we say, v'anizak v'amazik b'tashlumin. There are sometimes that both the nizak and the mazik participate in the payment. So what does shum kesef mean? Says our Gemara, my shum kesef, Amar Yehuda, shum zeh lo yeh b'kesef. Meaning to say this evaluation of the damage has to be done with money, that the court has to evaluate what is the value of the damage. Is it worth 100 or 200? And that's what he has to pay him. Indeed, we have a brayso that teaches this. Excuse me, we have a Mishnah that teaches this. Because what does the Mishnah say? The Mishnah it's a Tosefta. It says, Par she'zika talis, v'talis she'zika par. This is a little bit of a big cryptic what it's saying in this brayso, but it says if there's a cow that damaged the talis, or a garment that damaged the cow, so the way I understand this, way some of the Rishonim understand is you can't just say, okay, let's just trade the cow for the talis, because you first have to evaluate how much it's worth. That's the way Rabbeinu Hanano understands it. So the Rashi says as follows: let's say there is a cow that trampled over the garment, or a garment that damaged the cow in the public domain. We don't say let's just trade the cow for the garment. You told us a parashe zika talo. So you don't just say, okay, so the cow damaged my garment, I'm just going to take the cow. You can't say that. You have to calculate what it's worth. Or if the garment damaged the cow, you can't just say, let me take it. That's the way Rashi understands it. Okay. Each one has to be calculated. Shava kasef. What does it mean? Shava kasef. Tan Rabbanan. Shava kasef. Muhammad she'ain best in niskakin elon echasam sheyesh lan machrayis. That this teaches us that the court only goes down to collect from real estate. Avon kadam nizak v'tafas metalton based in gov and But if the one who is damaged goes down and seizes the movables, the court could collect it. Amar Mar, so let's analyze this. Shava kasef, Muhammad she'ein bezdin niskakin elon echasam sheyesh lan machrayis. The court only goes down to seize real estate. My master, how is this inferred? Amar Rava Barua, Davar. So what is? How do we learn this from Shava kasef? Davar Shava kol kasef. It's something that you can always pay money for. Mind you, what is something that any amount of money can be paid for? Davar she'en lo ona. That ona is the law that you can't price gouge. You can't charge more than a sixth. You can't charge 1/6. But if you charge more than a sixth, you have to give back the money. So that applies to movable objects, but not to real estate. And so therefore, we're saying any amount of money that you paid for it is going to be considered a valid sale. That's why it's called shava kasef. Avada v'shtaros nami ein lהם ona. Slaves and contracts, there's also no ana for them. So why don't we say that also? So we should also say and so therefore, and the brayso says, you only do it from nechasam sheyesh lan machrayis, but that's real estate, but not slaves and contracts. Something that can be acquired with money. The Gemara says, "Avada mishtaris nami niknem b'kasef." Slaves and contracts can also be acquired with money. So the Gemara says. "El Amaravashi shava kasef lo kasef." So it means to say that real estate is something that's similar to money, but it's not a commodity because you can't move it from place to place. Kahani kulu, but all the other things they're actual commodities, they're actually money, and so therefore it's a different law. Ramile Rabbi Yehuda Bar Chinanel, Rav Huna praise Rabbi Yeshua. So he's through a contradiction. One price says Shava Katz Muhammad Chain Bezin is Kakin on the Chasam Sheish on the Chayes. Court can only collect from real estate. But we learned in the other price say Yashiv Rabbi Shava Katz Subin. Meaning the court can collect the money even from brand. You can even pay him back with brand or with anything. So Hachamayaskina. So what are we talking about? Biyasmi. So orphans. The court can only collect from orphans with real estate, from the estate. Ibi asked me if that's the case. Ema safe and cut him these ekutavas metalton bezin govelaman. Maybe he asked me, am I bezin govelaman? So if you go ahead and you seize it, the movables, then the court can collect it. But if it's from an estate, why can't the court collect it? So the Gemara says, Kedamar Rav Nachman, Kedamar Rav Nachman, Shetafas Mechayim. Like Rav Nachman said in another circumstance, if you seized it while the person was alive, so if you seized the movables while the person who owned the estate was still alive, then even after he dies, the court can collect it. And the court, the action has to happen, the judicial action has to happen in front of a court. Problem, mocher nechasav. So this comes to exclude a case where somebody sells his assets, and afterwards the person comes to take him to court. The court can't go and seize the assets for damages. Shmami na. So the Gemara says maybe learn from here also. Somebody borrows money and then he sells it, even though there was a lien on it, the court can't collect it. Would you say that? No. Ella pratel bezin edyotu. So we see from here that the case has to take place in front of judges who are experts, but not judges who are commoners. That you can't collect damages in front of a bezin of hedyotos. It has to be in an expert court. That's the whole basis of the judicial system, is that the courts know what they're talking about. If they're just a bezin hedyotos, they don't know what they're talking about. It's not going to be a valid ruling. Okay, what a geschmack it is to see everybody on the daf this morning, and God willing,